Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. The opening topic today will be dealing with your tenant's personal property. Hello, everybody. Yes, another edition of Zoom Landlord Tenant Talk Radio every Saturday at 3 p.m. Today is November 30th, 2024. It is our Thanksgiving weekend, and we do have a lot of thanks to give this particular year. Let's talk about the song. The song was called Every Breath You Take, and that was performed by the Police. It was released in 1983, 41 years ago. And believe it or not, this song in 1983 was the most popular song of the entire year. And that was Every Breath You Take. Okay, you know how this goes here on this show. First, I'm going to have an opening topic, and then we're going to open it up to questions and answers. So if you are in the Zoom room, please get ready to, or you can actually do it now, raise your hands electronically so I'll know that you want me to call on you. But let's first talk about the topic of the day, and that is dealing with your tenant's personal property. Dealing with your tenant's personal property. Well, there's two aspects, and that is when the tenant is in possession of your unit and you have to deal with his personal property. And the second is when the tenant vacates your unit and you have to deal with his personal property. So what am I referring to first? We're going to deal with when the tenant is in possession. What do you have to do with regard to his personal property? I mean, it's his, except for one small thing. Your place looks like Sanford & Sons, a junkyard, because this particular tenant decides that he needs to store all of his personal property in either the common areas of the property, maybe on the balcony, maybe in the parking or garage area. And it just makes the place look so unsightly. It's very difficult to rent out your place. So how do you get rid of this personal property that's making your property unsightly? And of course, the common sense thing to do would be to go up to your tenant and say, hey, look, I didn't rent you all this other area. It's making the place look like a pigsty, and I'd like you to move it. And if the tenant moves it, problem solved. But what if the tenant doesn't move it? Then what can you do? Well, that could be a violation of your rental agreement. And if it is a violation of your rental agreement, you would be able to serve on your tenant a notice to perform or quit, giving him 3 days to get rid of the personal property. I want to share my screen. Okay, so I have a rental agreement, and that's free and on my website. It is evict123.com. Go into the free form section, and my rental agreement, which is free for you guys to use, has a wonderful bunch of paragraphs that protect you specifically in this situation and quite frankly in a lot of other situations. So if you notice in this particular paragraph 10 of my rental agreement, which I've just kind of cut out, it says tenant shall not store any object on the property outside of the unit, and only patio furniture is allowed to be placed on the balcony. So by having this provision there, ladies and gentlemen, and I'm going to stop showing my screen, you can then issue that notice to perform or quit, giving him the 3 days to remove it because that's an actual term in your rental agreement. Now, the other issue is sometimes you're giving this person a garage or you're giving this person a parking spot, and your tenant decides that he doesn't want to use it for a car or a passenger vehicle. He wants to use it for basically storage of his property. Again, it makes the place look unsightly. And it's also a situation where this could be a fire hazard. You know, there's a lot of grease and oil that is on the floor of a parking area or a garage. And if you're storing personal property there, that could be a situation where a fire could occur. So I have a paragraph in my rental agreement, and we're going to go to that right now. And as you can see in my rental agreement, it states that number one, we're giving you a parking spot, and maybe it's an assigned one, so we mark which assigned. And we're saying that you can only have that parking space for a vehicle that's registered in your name. You don't want your tenant having all of his friends come in, or maybe he's letting another tenant use it in the building and then charging that other tenant. So it's only for his use. And it says here, this space is exclusively used for the parking of a passenger automobile by the tenant. No other type of vehicle may be stored. So you can't have any other personal property in that parking spot. If you have personal property in that parking spot, that again is going to be a violation of the rental agreement, and you'll be able to serve that 3-day notice to perform or quit. And if the tenant doesn't comply with that, ladies and gentlemen, that's a great case for eviction. That's why it's so important to have a rental agreement which covers all of these items. And quite frankly, doing this for 48 years and walking into a court of law and saying, gee, I wish that term was in my rental agreement. Well, guess what? We keep changing that rental agreement so it has all these terms in it to protect you. And we're going to go on. But what happens if your rental agreement is an older rental agreement? It doesn't really touch on these topics. Or maybe you don't have a rental agreement at all. Is there anything else that you can do? Well, with regard to vehicles that are inoperable or not registered or licensed, that's a violation of most municipalities. I know Los Angeles City and LA County and a lot of municipalities state that it has to be a currently registered operable vehicle if it is in plain view. So in that situation, if you see that he's got car parts there, or maybe a refrigerator, or this inoperable vehicle that, I don't know, maybe the engine's like about 4 feet from the car, so you know it's inoperable, then we can serve a 3-day notice to abate the nuisance, that he's violating an issue in law. And again, we can look that up very quickly for the municipality that your property is located in, and we might be able to evict on that basis. So again, it is crucially important to have a proper rental agreement. You don't want your properties to look like a garbage dump where personal property is just strewn all over the place. So please enforce your rights, check your rental agreement, or maybe it's another violation of law that a law firm such as mine could bring forth an eviction if the tenant doesn't willingly remove the items. Now, of course, if the tenant willingly removes the items, we don't have a problem here. But the problem always comes up is that these people just have a different hygiene habits, and they believe that the whole property is theirs and they can just mess it up. And you can just imagine if that's the way they're treating your common areas, you can just imagine the way your apartment looks inside. Okay. The next issue is this is all when the tenant is in possession of the unit. But what happens if the tenant is vacated? What are the issues there? Well, first of all, we have to determine whether the tenant has vacated the unit or not. Sometimes you just really don't know. So we're not going to get into what to do with this personal property until we're sure that the tenant has vacated the unit. So how do we know? Well, there's a few ways. If the tenant has given you a written notice that they have vacated the premises, then you know for sure that they're out and you can change the locks. If the tenant hands you the keys, says I'm gone, well, that act of handing the keys constitutes vacating that unit. Another way that you know for sure that the tenant vacated the unit, even though it is a little gruesome, is if the tenant died. If the tenant died and he's the only occupant in the unit, then you know the place is yours. When a tenant dies, the landlord can take possession of the premises, assuming he was the only occupant, 30 days after the tenant last paid rent. 30 days after the tenant last paid rent. And unfortunately, if your tenant dies inside that unit, then you have an obligation for the next 3 years to tell any potential applicants that a tenant died inside that unit. So if you do have a situation, unfortunate situation where the tenant not only died, but died inside your unit, keep it in your mind that it is California law that you do have to advise other applicants that someone died in the unit. However, we live in a crazy state, ladies and gentlemen, and there's one exception to that rule. When you don't have to advise applicants when a tenant died in the unit. Only in California, ladies and gentlemen. And you're thinking, what could it possibly be? Well, I'm going to tell you right now. If your tenant died of AIDS, under the California law, you don't have to divulge that to any applicants. God only knows. Okay, but that's what the law is. Okay. The other way that you can determine that the tenant has vacated is if you believe that the tenant has abandoned the unit. If your tenant has abandoned the unit, then you have the right to proceed forward with an abandonment procedure. You just can't say, oh, he's abandoned, I'm going to change the locks. No, there's a specific procedure. The procedure is, number one, the criteria is that the tenant has to, you have a reasonable belief that the tenant has abandoned the premises and rent has been unpaid for 14 consecutive days. If that happens, then you can get a form, and God knows I'm going to show you that form right now, which is entitled Notice of Right to Reclaim Abandoned Personal Property. Actually, no, I'm sorry. This is a different form. This is a notice of a belief of abandonment, where you're going to mail this form to his last known address, which is going to be your property. And if in fact he doesn't respond to you in writing, and he has 18 days from when you mailed this notice to him, that no, I haven't abandoned the premises, and this is a place where you can serve me by certified mail for any legal process. If he doesn't send that letter within 18 days, and again, you have to have a reasonable belief that he's abandoned the premises, and rent has to be unpaid for 14 consecutive days. Then you send out this legal notification to the last known address, which is your property. And if he doesn't send you notice, then you have the right to go in there and change the locks. So that would be another way that you would determine that the premises have been vacated by your tenant. Let's move on. Another way that you can do that would be if the tenant was evicted. If the tenant was evicted and the sheriff did the lockout, you're going to get a notice of eviction from the sheriff's office. You will hang on to that notice, because if the tenant ever comes back, all you have to do is call up the local police department, not necessarily the sheriff, but the local police department for that area. And then you'd be able to, if the tenant comes back, you'd be able to arrest him as a trespasser. Okay, that's another way you know the premises have been vacated. The last one is not one. If your tenant is arrested, ladies and gentlemen, your tenant is arrested and put in jail, that doesn't mean he's vacated the unit. In fact, if you think about it, he really wants to come back. So don't use that as a ground. So if that's the situation, you're probably going to need to bring forth a regular eviction lawsuit, maybe based on non-payment of rent, because he is not paying. Okay. Now we know, and we'll take for granted, that the tenant has vacated the unit. The first thing you do when you get inside that unit is you take pictures. You want to take pictures of any of this, quote, personal property that's left behind. And there is procedures what you need to do with this personal property. However, if it's just garbage, take pictures and you can throw it away and start cleaning up the unit. But if there is legitimate personal property there, then you have to deal with it. So what types of personal property could the tenant possibly leave? Well, some of these tenants are so cruel, ladies and gentlemen, that they leave either being evicted or they leave on their own accord, and they leave animals in the unit, dogs, cats. It's absolutely insane what they leave behind. And then, of course, the landlord is charged to deal with it, because, quite frankly, that's the personal property of the tenant. If it is a live animal, then what I recommend, certainly in LA County or in different counties, I would call up the Los Angeles Animal Services. Their phone number, which I will have in the edited version of this broadcast, is 888-452-7381. That's 888-452-7381. This will also give you information as to where the nearest public shelter is, where you can drop off this truly abandoned pet. Very obnoxious of these tenants to leave pets behind, but we see that all the time. And by the way, sorry to give you this news, if you do drop off a pet to one of these impound centers, these public shelters, just to let you know, 70% of these animals are euthanized. So that's what's in store for them. Sometimes you're going to have a tenant who leaves a vehicle behind. Well, if the tenant does leave a vehicle behind and he is vacated the unit, either formally through an eviction or he's told you so, you can have that car immediately towed. So get a towing company to tow it. If the tenant wants his belongings, then he's going to have to, or his car, he's going to have to go over to the towing facility. He's going to have to pay all those storage costs and towing costs, and then he'll be able to get his car back. You don't have to wait on that. If there's a car left after the tenant vacates, you can immediately have it towed through one of these companies who are happy to do it, because quite frankly, they're either going to charge the tenant who picks up his car a bunch of money, as we all know, or they're going to do a lien sale on that car and they'll sell it and be compensated by way of the sale of that vehicle. Okay, so we dealt with animals, we dealt with vehicles. What else is left on the property? Well, you get the general personal property that's left behind, but quite frankly, we've seen methamphetamine labs, we've seen guns, we've seen sex toys. You have no idea the stuff that's left behind. These are the treasures of the tenant. So unfortunately, after the tenant vacates, you have to account for that. So again, you've taken pictures of this stuff. Now, the good news is if the tenant was evicted by way of a sheriff, the sheriff actually did the lockout, then there's no forms for you to fill out. You have 15, the tenant has 15 days to retrieve his belongings. If the belongings are worth less than $700, you can toss it away or have a garage sale or do whatever you want with their bedridden stuff. Or if it's worth $700 or more, you have to hold a public auction, which I'm going to get to in a minute. But with regard to other items, okay, what is the form that you need to do? That form again is on my website, and I'm going to share my screen once again. And this form is called Notice of Right to Reclaim Abandoned Personal Property. I think you can see it here. Let me see if I can make it a little bit bigger for you guys. And you fill this out. Here I have in it John Smith. This is the address of the property. This is also telling him, this would be his address where he's living now, if you knew where he was living now, but normally you don't. This is the address where the property is located. And here I've just kind of listed some things. You don't have to state each thing in particular, like 12 dishes and 14 forks. Just do assorted dishes, as I wrote here: couch, washing machine, assorted clothing, 4 chairs, and 3 umbrellas. And then you tell your tenant where he can claim this stuff, which is generally it can be the address of your property, or you can move it into the garage, or you can have it brought to a storage area. Technically, and these are what these dates are here, it tells the tenant, hey, if you want to avoid storage charges, then you got to have it picked up prior to, and I would make this a date here. But after that date, then you're going to have to pay the storage and moving costs. Finally, down here, if you do send this form and you're mailing it, it's 18 days from when you mailed it that the personal property is deemed abandoned. So here, this notice was done on, well, let's go move it up, on December 1st. So I made the cutoff date December 19th, 18 days later. If the tenant doesn't retrieve his belongings at the end of that 18-day period, then you have the right to proceed forward with either tossing it away if it's worth less than $700, and there's the boxes to check on that form, or you need to hold a public auction. So it's really difficult to do a public auction, ladies and gentlemen. There's notices that have to be posted in the paper, certain time periods that are involved. So I recommend a company. I have no affiliation with this company except that I do recommend them. and I'm going to share my screen, and it's called All State Auctions. And they're very good in terms of holding these auctions or even vehicle lien sales. They do a bunch of other things. They have their brochure up there, and their phone numbers on the bottom is 818-994-8243. Once again, 818-994-8243. So this is where you've gone through an abandonment procedure, either formally with that notice, or you've done it where the sheriff did the lockout, but the property is $700 or more. You're going to need to hold an auction so someone doesn't come back and sue you. So those are the issues with regard to um, having a sale of your property. There's one more way to avoid all of this issues. Sale of the property, serving notices. It's really simple. And that is get yourself the Dennis Block lease. Because in the Dennis Block lease, and I'm going to try to share my screen again. There we go. I have a provision in my lease. It's wonderful. It says, once a tenant vacates, all personal property left in the unit shall be deemed abandoned. Landlord may dispose of said items in any manner landlord chooses. No notice is required to be served by the landlord. If the tenant signs this rental agreement, I don't care that he left a Rolex watch. Those treasures are yours, ladies and gentlemen. So again, this is in my rental agreement, which is on my website, which is evict123.com, evict123.com. And that, ladies and gentlemen, concludes our discussion on what to do with your tenant's personal property, whether he's in possession or whether he's out of possession. And boy, there is a lot to that subject, ladies and gentlemen. We're going to open it up now to the next part of this Zoom/YouTube meeting, and that is we're going to open it up to questions and answers. And we know that this is just for informational purposes only. It's not a substitute for legal advice. If you do want to talk to me and you are in the Zoom meeting, very simple. Electronically raise your hand, and I'm going to try to get to everybody today. Also, if you have an existing case with me, then I'm very happy. But we do not talk specific cases here, so just phrase your questions in a very general legal form, and I'm happy to answer it. And last, to make this more enjoyable, if you do have a camera and you are talking to me, turn it on, because it's really nice to have a conversation with somebody who I can see, and I think it makes it better for the audience as well. And with that, we're going to open it up to questions and answers, and my first person will be Jim Polina. How are you?
Hey, Dennis. Happy Saturday. Hope you had a good Thanksgiving meal with your family.
I had an excellent one. Thanks for asking.
Good for you. All right. I have two questions. One, I have a house under statewide rent control, AB 1482. And if I raise the rent, can I also raise the security deposit, the same percentile?
The answer is no. If you read the code section with regard to security deposits, it's the amount that you can ask for is only the amount when the tenant came into the unit, when the tenancy was at the inception of the tenancy.
That's a 1482 clause?
No, it's actually in the Civil Code 1950.5.
Oh,
So it says that. So I would just keep that's the same. Also, we do know that under the new rules dealing with security deposits, which came available as of July 1st, 2024, you can only charge 1 month security. I understand you're raising the rent, but you can only charge 1 month security. And unless you have a total of 4 units in two separate properties, if you do, then you can go 2 months rent.
okay. My second question is, I had a workman oddly cause a flood in a bedroom. Had to replace the carpet, replace drywall, and tenant stated that the house was uninhabitable, and so he put a claim into his renter's insurance policy, and he temporarily relocated. Is he still responsible for the total rent of the house?
No, for the time that you could not provide a habitable place to him, then that on a prorated basis, you shouldn't charge rent for that period of time. Now, if the flood occurred by his own negligence, that's a whole different story. But if he didn't cause the flood, then prorated, I would not charge him for the days that he couldn't use the unit.
And could his rental insurance carrier subrogate against me because I caused the loss for the insurance carrier?
Potentially, they could. In other words, when anybody has an insurance policy and you're paying for the negligence of, let's say, another driver, technically they pay the claim, the insured, and they can go after the other driver. And I guess in this situation, they could go after you for the losses sustained as a result of a negligent act. If it wasn't a negligent act, and for example, a pipe just burst, then that wouldn't be your fault.
But an accident, is that negligent?
Accident is not necessarily negligence. There has to be a dangerous condition or a condition in the property that you knew or should have known and had an opportunity to fix it and you didn't.
Thank you so much, Dennis. Appreciate it.
Nice talking to you, Jim, as always. We're moving on to Diana D. Diana D, how are you?
I'm good, Dennis. How are you?
Good. Nice to see you.
Nice to see you too. Dennis, I have two questions. One is about your topic. Can the 18-day abandonment notice run concurrently with the notice of abandoned property?
Technically, it could, but generally speaking, you're not going to know what personal property remains until the premises are abandoned.
Oh, okay.
So on that basis, it's really not considered an abandonment until the tenant has vacated the unit. And the
Can
tenant has
you,
formally vacated the unit after the notice for belief of abandonment expires.
okay. And can you do like gardening work if it's like, uh, send the gardener over if it's all overgrown and stuff?
Oh, of course, you could always do that. Even if the
Okay.
tenant's actually living there, you can always serve a notice saying, "Hey, we're coming in to do maintenance," because you're not doing it.
Okay. Okay. So now my real question. I know you've talked about this before. So if you have a tenant that wasn't paying rent and you served the 3-day notice and they still didn't pay rent, but now they're threatening you with stuff, can you, if the tenant wants to negotiate some sort of settlement and a cash for keys, can do you have to have a UD filed and recorded, or
You
I'm
don't have
getting
to have a UD
misinformation.
file and recorded to do a cash for keys, but that's just an agreement. If the tenant doesn't vacate at the end of that agreement period, you're going to have to file some sort of a lawsuit, assuming
Okay,
the
to make it
jurisdiction allows you.
to
Yeah.
make it
Oh, to
enforceable.
make it enforceable, yes. You need to have something called a stipulated judgment. And by the way, I didn't talk about this, but with the personal property, when you do a stipulated judgment in court where the tenant's going to leave on a certain basis, I know my firm also adds a clause into that stipulated judgment which says after the tenant vacates, any personal property is deemed abandoned and the landlord can dispose of it as he sees fit. So that's another point you want to put into your stipulated judgment. But if you want to have something enforceable, that is, I can take this piece of paper to a sheriff and get them evicted. Well, you can't do that with a quote cash for keys agreement, but you can do that with a stipulated judgment. So you would have to have a lawsuit on file.
And it has to be served also.
Well, I mean, if the tenant, you don't have to. If you file an eviction lawsuit, so there's a lawsuit on file, then you walk over to the tenant with a stipulated judgment with a case number on it. You don't have to serve them with the lawsuit. I mean, it's logical that you would.
Okay, I'm lost on that one. Where did the stipulated judgment come in after
Well,
after?
you can't do a stipulated judgment until you filed the lawsuit. So the
Okay,
day you file the lawsuit and you have a case number, then you could prepare a stipulated judgment, walk over to the tenant that has the case number on it and say, hey, do you want to agree to these terms? And if the tenant signs that, then it's enforceable.
okay, got it. Thank you.
Thank you. Okay, let's move on to Bert. How are you today, Bert?
Hi, Dennis. Thank you for taking my question. This is regarding interest on security deposit. I have not really been paying interest on those deposits, but if I would want to do an unlawful detainer case, will the tenant's lawyer automatically look at one of these things like interest on security deposit to throw the case out, or?
Yes, that certainly can happen. But again, interest on security deposits are only required in the city of Los Angeles, and they have to be paid on a yearly basis. There's a chart which I'm going to share right now for you guys that you can get by actually, it's on my website. And if you go to where the gray buttons are and it's called legal issues, you're going to see this is the first one there. Let's share this chart with you. Again, this is only for the city of Los Angeles. And again, it's in the gray buttons on my website under legal issues. You'll see this one first. And this requires that interest be paid on security deposits. And they have, if I move down here, make this a little bit bigger, you'll see that they tell you what the interest is. Bottom line is, if you give your tenant 20 bucks, it's never going to be more than 20 bucks. But just technically, you're supposed to do it per year. So what happens is in these situations that you have to have a 3-day notice that states the correct amount due in that notice. So the tenants are using it on the basis that, look, you had to pay me interest on security deposits. You're in violation of the rent stabilization ordinance. And if you're in violation of the rent stabilization ordinance in any part thereof, then that's a defense. So we have that in our reminders when we send this out to our clients for the city of Los Angeles. So if there is, then please pay that interest on security deposit. Send a check of $20. Now, it's funny because I have a term in my rental agreement, again, because you just sit there and over the years, you put this in, and it's towards the end of my rental agreement, and it states something to the effect of that if interest is required by the municipality on security deposits, then I am charging you a management fee equal to 5% per annum or whatever the interest on security deposit is. And therefore, the two will basically offset each other. So I have that as a last stage effort in case we do get caught. So again, these are the reasons why I really recommend using my rental agreement. It's free, ladies and gentlemen, and it does just deal with these situations that you come across when you're in court.
And if I want to start paying now, should I just focus on
Yeah, I
2024 or
would go
should I
to
go?
that chart, add it all up, all the percentages, and give them and say, here's your interest, and have a good time with it.
Okay. And are there typically other items that a tenant's attorney would look at to throw a case out? So interest on security deposit is one thing. Is your unit registered with RSO? Are there other items that they typically look at to throw the case
Well,
out?
a lot of municipalities are now requiring that you send notices to those municipalities, and if you don't, then you lose your case. Let me pull up that one here. If you go to the free forms section, I have a chart here that are special notice requirements, which we talked about in a previous show, but I'll share it too again. This is again on my website, and this chart shows you that, for example, if you're in Culver City, you're serving a 3-day notice to pay rent or quit. You've done everything correctly. Well, within 5 days, you have to mail a copy of that notice to the Culver City Housing Division with certified mail return receipt requested and the proof of service that you served the notice. And you can see all the requirements as I go down here, depending on which jurisdiction, including, I always get a kick, Cudahy, which is 2 square blocks. Why they need rent control, God only knows. But in any event, you can see, and so you might want to check this form. It changes from time to time, and we try to keep it updated. But right now, I believe it is updated. So those are the tricks. There's also notices that need to be posted on the property. Unincorporated areas of LA County require one. LA City requires potentially 2 if your property is under RSO. And then if it's also under what they call the just cause ordinance, there's another notice that needs to be posted in a conspicuous spot on the property. There's just a myriad of things. I'll give you one. If you have a property in an unincorporated area of LA County, you can't serve a 3-day notice unless you're above the threshold. So the threshold is $2,086. So let's pretend, and you have to put how many bedrooms in the notice. So I'm in unincorporated LA County. I do a 3-day notice. The notice is for $2,100. It's above the threshold. And I write how many bedrooms right in that notice. 1 bedroom. Well, guess what? Unincorporated areas of LA County require that you also state in the notice what the fair market value for a 1-bedroom unit is. So it's got to also state, and by the way, the fair market value is $2,086. So it's not like it used to be. You know, when I started practicing law back in 1976, any landlord could fill out their own 3-day notice, and a lot of them filed their own lawsuits, and nothing can go wrong. Right now, you can't even do your own 3-day notice, and I'm really not saying that just to create more business, but if you're intending to go forward with that 3-day notice, invariably a landlord is going to make a mistake, and if the landlord makes a mistake, you're going to get thrown out of court, and it's just not worth it. Our fee structure now is we don't charge extra for serving the notice. It's all inclusive. Anyway,
Thank you.
Bert, thank you very much. I hope I answered your question. We're moving on to a number. Oh my God, 427-068. I'm going to ask you to unmute yourself. 427-068. Please unmute yourself. Okay, I guess you're being a little shy today. We're going to move on to I think a client of mine, Richard Klug. How are you, sir?
Just fine. Thanks. I'm kind of worried about the LA City Council.
You and everybody else.
Right. And my question is about the big picture. Is there any chance of relief, do you think, coming from cases that might eventually reach the Supreme Court? I mean, it seems like the Supreme Court has no interest in this, but are you aware of anything that may be cooking?
I am not. I know there was a case that came before the Supreme Court dealing with the legal confiscation of property by way of a concept called rent control, which certainly it is. But this was after the Roe versus Wade decision. I don't think the Supreme Court had the guts to say, hey, you know what? Rent control is illegal. It's unconstitutional. It's under also the contract provision that 2 people should be able to contract. If I want to charge raw rent and you want to pay for it, you sign a rental agreement, then I should be able to charge what I want. But of course, that's not the case under rent control jurisdiction. So there's really nothing on the horizon. As I've said in previous shows, that what you need to do is you need to make sure that whenever you can raise rent, regardless of how nice these people are. You've got to get your property to market value. You're somewhat shielded from the evils of rent control. And I mean the evils of rent control, which all it does is cut down on the supply of housing and therefore escalates rents. Politicians know this. They don't care. So the other thing is if you do have a low-paying tenant and the tenant does have a violation of their rental agreement, I would seize on that moment, the old luck and timing from last week's show, and bring forth an eviction because you're rewarded. You're rewarded on the basis that the city council currently for Los Angeles and almost every municipality says that, and it's by law, once a unit is vacated, you have the right to raise the rent to market level. So you've got to take care of your advantages when they arise. Thank you very much. Richard, let's see, 1 second here. I'm going to go back to that number 427-068. Are you ready to unmute yourself? Hello.
Hi, Dennis. Is that my number?
That's what's being displayed.
Oh, okay. It's not.
427-068.
Yeah,
You
that's
might want
not
to
my
go into your
number.
Zoom credentials and put a name in, but I don't mind calling you that.
Oh, okay. This is Dave. So I'm sorry about that. I didn't know.
You're not in prison right now, and that's your prison number, are you?
No, I'm
No?
in Westwood.
Oh, okay.
I don't know what it's coming through, but that's strange. If I could clear up one thing first, you said something about security deposits could be 2 months in certain situations.
Yes, if you own a total in the state of California of 4 units divided between a maximum of 2 properties, then you have the right to get a 2 month security deposit. So, for
Oh,
example, if I own 2 duplexes, different lots, but different properties, then I'm allowed for those to get a security deposit equal to 2 months rent. Otherwise, you're limited to one. Now, what I've said at previous times is that if you have a 3 unit building and a 4 unit building, well, that's seven, so you're above 4 units. However, just put one of them into an LLC, a limited liability company, and then that ownership only has three, and the other one is an individual, which has four. So then you're able to get a double security deposit for both buildings.
oh, okay. Let me go back to my question then. The original question, does the requirement to report positive tenant rental payments to credit entities apply to individual mom and pops? And also, does the interest on security deposit apply to individual mom and pop non-SRR RSO
Okay.
units?
Okay, interest on security deposit only applies if a local municipality has that law. And so far, Los Angeles City is the only one that has that law. That's number one. With regard to a law that is passing as of January 1st, and I really haven't gone into it, it's going to require landlords, I believe it's of 15 units or more, that if the tenant requests, I can't believe this, if the tenant requests that positive payments be uh, uh, told to credit institutions, and a landlord has the obligation to do it, though he can get asked to be reimbursed for what the credit institution is charging up to $10. So you can go back to the tenant saying, okay, if you want me to do all the positive times that you made payments, then you need to pay me, but I have to do it under the law. But what the morons in Sacramento didn't understand is if you're going to give landlords the idea that they have to positively tell credit institutions when a tenant didn't pay the rent and require landlords to do it, then guess what, landlords? Then you should be doing it, since you now are going to easily know the procedures, because you have to do it for the good tenants. Well, now you're going to do it for all the bad tenants. So all this is going to do is any time, and who doesn't pay their rent late once, right?
Uh,
Something goes on once, you know? So anytime you now have the wherewithal, you know the procedures for telling the whole world that, hey, this tenant paid his rent late. So I think this is really just going to backfire for any tenant that is requesting that, yeah, show my good paying habits to these credit institutions. But then again, this is another legal boondoggle that's just designed to raise the cost of landlords to run their building, which, guess what, makes landlords raise rents.
so in the interest on security deposits, you were saying that an individual unit, mom and pop, say they only own one house.
One house, well, if you're under RSO, the rent stabilization ordinance, so one
Right.
house wouldn't apply. But if you have, a duplex, then you're going to have, and you're only a single mom and pop, you have to do that. Anybody who owns RSO property has to account for the security deposit for the city of Los Angeles.
Okay, RSO properties. Great. Thank you.
Thank you. Okay, and you got to get your name changed on that, okay? All right. Here's a regular. Mr. Sam, how are you today?
Yes, hi Dennis. Thank you for taking my call. Question. Okay, so this regards tenant estoppel certificates or confirmation of lease certificates as they're otherwise known. Suppose that a lease has a certain contract rent and the estoppel certificate presented for their signature because the landlord is getting a refinance and the lender wants to know from the tenants what the terms and conditions of their leases are. Um, Suppose the tenant signs something that is different than perhaps a greater security deposit, perhaps a greater rent than what is in the lease or what is permitted by the RSO in the city of Los Angeles. Um, and then
Well, I
the
would I would turn that estoppel in because you're trying to get a loan on the property. I
okay,
would turn that estoppel in, but I would immediately send the tenant a letter. You filled out this estoppel, And there's a bunch of untruths there. You don't have a security deposit that's this amount. It's only this amount. And by the way,
Right.
this is what the rent is. Okay.
Yes.
So I would just send a confirming letter. But you're in a situation where you're trying to refinance the property and the lenders are looking for the tenants to sign an estoppel so that they can guarantee, even though they have a copy of the rental agreement, they want to see that, hey, currently this is what the story is now. The question, Sam, is do you think a tenant has an obligation to sign an estoppel?
Yeah. Now, related to that, suppose that the tenant fails, neglects, or refuses to sign and return the estoppel certificate for whatever they want to put in the blanks, even if filled in or not filled in. Can a lease provision validly say that you appoint the landlord or the landlord's agent as attorney in fact for purposes of execution of that estoppel certificate for the relying party, and within 10 days of non compliance of suppose that the rental agreement provides that they must execute this estoppel certificates within a certain number of days, say 10 business days. They fail, neglect, or refuse to do so. Can the landlord validly have a provision in their lease saying that you appoint us as your attorney in fact for purposes of execution of an accurate estoppel certificate for the relying party, say a lender or a buyer?
I don't have any problem with that. I never considered that. I think it's an interesting idea. The problem is, would the lender buy it? Because they're looking
Or
at
the buyer of the subsequent purchaser of the property.
yeah,
Who
well, would the subsequent purchaser of the property
Yeah.
be willing to accept that? Because, hey, this tenant just doesn't want to sign it at all. But the other way that I have in my rental agreement is that it's a violation of the rental agreement if you don't sign an estoppel when presented one to you.
Okay, and they have how many days to comply?
It just
Usually
said when presented. So
when
here it
presented.
is. I gave it to you. You didn't give it back. Here's a 3-day notice to perform or quit. And we actually have done evictions on that basis. And quite frankly, if you're buying the property, especially a rent control property, and the tenant doesn't want to sign the estoppel, then you're thrilled at that point because you know the current owner of the property is going to go through an eviction and you're going to get a unit that is vacant, which is much more valuable these days than a unit that's occupied.
Thank you. Thank
All
you.
right. Good question, Sam. Very interesting idea. Okay. We're moving on to David Khosravi. I'm going to ask you to unmute yourself.
Hi, Dennis.
Hello.
Thank you for doing this for us. Couple of questions. I'm an agent and also I manage properties. Do you think it's best to just go with the MLS or the SRAR lease agreements when you are managing, when you're signing lease agreements for other people?
Well, I mean, they have excellent rental agreements. They cover all the legal requirements. I think my lease covers all the legal requirements, but what it does do, there's so many nooks and crannies in my lease that gives the landlord the opportunity to terminate a tenancy. When these other real estate, like the CAR forms, California Association of Realtors, these forms, they're not really considering rent control. So they're not really looking for ways to get tenants out of your building. In the past, once that lease was over, or if it was month to month, all I had to do was serve a 30-day notice. You're gone. Goodbye. But now it's a life estate. A tenant can sit there until your grandchildren have grandchildren, quite frankly. So we try to put in a bunch of terms and conditions in our rental agreement, which will give the landlord an edge. Not that they're going to necessarily use it, but it gives them an edge in those situations when you've got the tenant from hell.
I understand. And being an agent representing the landlord, for my own protection, I think I like the CARS agreement, which is totally different from somebody else who manages their own properties. With that said, how can I add an addendum to the CARS agreement? Is it just an amendment and take some of these paragraphs from your lease?
Yeah, it would be an addendum to the
Addendum.
rental agreement. And so just write, see addendum, page 2, and then you have everybody initial it and sign it.
And when you're signing a lease agreement, just curious, if somebody who is a tenant also is 20 years old, has zero credit whatsoever, how important is it to add their name to the lease agreement as opposed to just adding their name as one of the tenants living there?
Every adult who's moving into your unit must be listed as a tenant and must sign the rental agreement. And every tenant who's an adult must have their credit checked.
Got it. And one last thing, just so you know, I'm sure you know the answer to this, but City of West Hollywood does charge interest on their security deposits, and it's 5% for 2023, which is, I mean, insane. I don't even get 5% on my deposit in bank, but you still have to pay 5% interest on security deposit to tenants.
Yeah, so I should know that because I have a lot of property in West
I
Hollywood.
know.
I don't manage it myself, but yes, now that you think about that, yeah, no, it's absolutely insane. But I don't think West Hollywood makes you pay it yearly, do they?
Yes, they do.
Okay, well then we learned something from these broadcasts. All right, thank you very much, David. Oh, by the way, David, before I let you go, let me see if you can unmute yourself.
Yes,
So you manage property for people?
I do. I changed companies, and I'm with a different company, I mean, brokerage, that they, again, most brokers don't like it. So I was recommended just get your own brokerage license so you can manage properties under your own brokerage and then hold your license for real estate under this other company. But yes, I do manage properties right now for myself.
David, you seem very knowledgeable. Do you want to tell everybody what company you work for and your phone number?
Sure. I work for Beverly and Company, and my phone number is 818-292-3932.
Thank you very much. And by the way, if you missed that, you can always listen to it back on our pre-recorded YouTube. Thank you very
Thank
much,
you.
David. And we are moving on to Jonathan Kennedy. How are you?
Well, thank you. I also manage property for others in Palmdale and Lancaster.
And what's
So
your phone number, sir?
661-945-8888.
That's a good one. And what's the name of your company?
Kennedy Real Estate Management.
Okay, and that's in the Palmdale, Lancaster area?
Correct.
Very good. How can I help you today?
Thank you. So I've heard your uh, scheme for avoiding renting to Section 8 tenants, which is to only offer month-to-month tenancies. Is that still correct?
It is correct, except for a city called Glendale, because they're requiring that any tenancy, and I don't see how this is legal, has to be a 1-year lease.
Oh, wow.
But other than
That's
that, it's been successful. So, but you can't just pick and choose, oh, you're Section 8, I'm only going to do month to month. You have to advertise, we're only doing month to month.
right. Now, I see the value in many situations of having a lease because I've had tenants, move in with no intention whatsoever. They're just using it as an interim. They stay 3 months because they sold their house and they're not moving to Tennessee for 3 months. And it just causes a lot of work
And
for
I see
nothing.
that, but I think that's more of the rare situation than the average. And also, let's pretend that the guy signed a 1-year lease and 3 months later he's off to Tennessee. Are you chasing him?
No, no.
So what's the point?
And
But
plus you
but
have an obligation to mitigate damages. So,
Right, exactly. So the issue really is Section 8 is by, I have some clients that love the business concept of Section 8. Most of my clients don't like it. I told in a previous broadcast, if you have one Section 8 tenant in your building, just one out of 400 units, then every tenant needs to be served when they don't pay the rent, a 3-day notice to pay or 30-day notice to quit. If there's one tenant out of 400, can you imagine? Then the law requires under the federal rules that you serve that 3/30-day notice. It's insane.
well, my question is, would you consider it to be a viable alternative to your position to possibly offer a property for lease until, say, like if I had a property right now, I would say this is being offered for lease until June 30th.
Well, you
And
could
then
do,
on
let's say,
June
like
30th,
I'm sorry to interrupt, but you could do a 6-month lease because Section 8 requires a 1-year lease. So you could do 6 months.
right. So if I just offered it on the open market until June 30th and got a tenant. And then as June 30th approached, I then offered them a 1-year lease. Do you think that that would fly?
I don't have a problem with that at that point, but what if they now been there and they now want to join Section 8? Okay, then you'd have an issue because at that point, then you're offering them a year's lease. So,
Okay. That's something that I found very unusual for a tenant to get Section 8 after they move in, but maybe
exactly.
that's not. I mean, it is. I've never had that happen where they've come to me and said, "Hey, I got a Section 8 certificate. Yeah, you have to take it now."
Yeah, and that's
Uh,
true. And I've seen examples of that, but I deal with so many landlords, but I have seen examples of that.
okay. I have another question. I'll wait until next time to ask it. It's about the whole idea of not being able to require a credit report from Section 8 from people who receive subsidies.
Yes, I
Um,
have talked about that, but we'll do that. We'll save that for next week because I do have other callers. We're going to go now to Jan. Jan, how are you?
I'm doing great. Thanks for taking my call. I have a duplex and I've had the same tenants in each unit for over 10 years and the same lease. And I like your lease. Is there a way to add, especially the two clauses that you talked about? Is there a way to add those? Like when I do a rent increase, is there a way to add them?
What city?
Los Angeles, rent control.
I think, for example, on that if you vacate and leave personal property behind, it's deemed abandoned. I think you can do a change of terms of tenancy to add that by serving a 30-day notice. Yes, I don't see any
And they
problem
don't have
with
to
that.
sign it, right?
No, a change of terms of tenancy, just like a rent increase, which is a type of change of terms of tenancy, is never signed by the tenant. So as long as you're not decreasing services or increasing the rent in violation of a local rent control ordinance, you're fine with that.
Last question. Since as I've had these tenants for over 10 years, actually one of them 20, and one of them, his mom died and he's living there now. So remember how you were saying it could be our grandkids who have to be their landlords? It's
Yes.
kind of happening. So my rent is way below market value. Do you recommend that I get professional help to get the, I'm working on some the staircase right now, capital improvement. And there's this other thing where it's like fair market value rent increase.
Okay, well, first of all, we're talking about rent stabilization, correct?
Absolutely.
Okay, so
Well,
you can
rent control, that's the same
right,
thing, right?
right. So you're talking about capital improvement. Technically, you can get additional rent for a capital improvement, but it's amortized between all of the units over 5 years, and the tenants only have to pay 50%. It works out to like $35. I don't know even if it's worth it. I mean, if you do have to put a new roof in and a new HVAC in, then maybe you'd want to apply for that. As to that, all rent control statutes, so that they don't seem that they're violating the Constitution for the United States, have to have a provision that a landlord's entitled to a fair rate of return. But you can apply for that, saying my rents are real under market value. The city will never give you a rent increase based on that proposition. Never.
Oh. So it's not worth hiring someone to help me do it.
Absolutely waste of money. The city will do nothing for you. You can show, hey, my mortgage payments are this, my utilities are this, this is the rents coming in. I am losing money. My property taxes, I'm losing money every single month. But it makes no difference. They're not going to give you a penny more. You know why? Because they don't like you, because your name is landlord. That's why.
Okay.
All right, Jan, we're getting close here. We're going to move on to Harold. How are you, sir?
Right. Hey, just a quick thing about the Lakers. I'm glad that new player, that rookie, is doing super great. I think it's going to help.
Don't talk to me. We've lost, I think, what?
No, but that guy,
three out of four games, or four out of five games.
I know that new player is going to bring it back. That Connect dude is going to bring it back. I'm looking forward to it. Anyways, so this is like a question where if I raise the rent more than 10% or whatever that is, once you get past that threshold, if they say no, you have to pay for their way out.
That's for areas of the city of Los Angeles and some other areas as well. Yes.
Right, right. So that would, I'm saying if what do you call it? I own my own place and I live there. There's a name for that. I forgot the name. In a house, single family resident. I'm the owner.
Well,
And I
if
live-
you're the owner and it's a single family residence and you live there with the tenant, then you have the right, you can just terminate the tenancy with a
But if
6.
right, I can just terminate. But besides that, if I offer him like say you got to pay an extra 200, which is basically like say 15%, and he says no,
Then you would have to pay the relocation, which would be 1 month's rent.
oh, it's just 1 month. Okay, I thought it was
For
like
for a single family home, it is, yes.
Okay, good, good, good. Thanks, Dennis. Good stuff.
All right. Well, ladies and gentlemen, we have made it to the end of another Zoom Landlord Tenant Talk Radio. I really want to thank everybody who participated today because I think without exception, almost everyone had their cameras on, and it does make the telecast much more enjoyable. I would ask that everybody, if they'd be so kind as to, if you're on YouTube, to subscribe to my channel and please press that like button because it does really help me out. And with that, I am signing off. Have a great Thanksgiving weekend, everybody.